Hello and welcome to another episode of my podcast, Think Like a Lawyer. Today we'll be discussing breach of promise to marry, a legal perspective. My name is Angela Siedu. Now, as ancient as the concept of a lawsuit in respect of a breach of promise to marry seems, the prevalence of the repudiation of a contract to marry and the wanton acts of the jilted partners is a cause for concern. Breach of promise, although not actionable in most jurisdictions, is a breach of a promise to marry another. In other words, it is a broken engagement. The principle of breach of promise treats the promise to marry as an enforceable contract which may entitle the non-breaching party to receive damages. Per Amwa AGA in Enin vs. Kinfo, it opined that a promise to marry generally was in law a promise to marry within a reasonable time. As such, where a party unreasonably delays the fulfillment of his promise to marry another person, he or she could be held liable for a breach of the contract to marry. But if both parties delay the fulfillment of the contract unreasonably, it must be considered as abandoned by mutual consent in the absence of evidence to negate this inference. According to Mensa Bonsu in her article, The Action for Breach of Promise to Marry in Ghana, New Life to an Old Rule, the common law action of breach of promise to marry was part and still remains a part of the received laws of Ghana, although it has rarely been used. I do not intend to rehash some of the criticisms against the action for breach of promise to marry, which led to its abolition in England, Wales, and America, but only to state that it could be useful tool in Ghana. Now, breach of promise to marry can be categorized into two, namely non-performance or actual breach. This occurs when parties fix a date for marriage and one of the parties does not show up. Or two, anticipatory or speculative breach. This occurs also when before the date fixed by parties, one of the parties does something to suggest that the marriage will not hold. Examples include eloping with somebody, impregnating someone else, or performing marital rites. What must one prove? To qualify for an action for breach of promise to marry, the plaintiff must prove that 1. There was an actual promise to marry and such promises had been exchanged between two parties. The court will not deem a promise to marry from mere romantic talks or discussions about parties' future. The promise to marry has been breached by one of the parties. That is the second thing that one must prove. There is no law requiring that such a contract must only be in writing. As such, the existence of a contract to marry can be inferred from conduct or can be by words. In Kofi vs. Abochi, when the parties were together for several years and the plaintiff contributed towards the education of the defendant, and upon the request of the defendant sent drinks to her parents, the court, per Samson J., inferred the existence of a promise to marry. Now, what happens when the plaintiff is successful in the breach? Even if a plaintiff prevails in their lawsuit, obviously they cannot force a defendant to marry them if the defendant does not wish to do so. In other words, if the plaintiff prevails, they cannot be awarded specific performance as a remedy. A plaintiff's award of damages may be subject to mitigation or a reduction if acted in some way to contribute to the breach. In Baker vs. Smith, when the court noted that an engagement to marry is not merely a spiritual matter, and this action is not to compel marriage upon the contract, but to recover damages for not doing it. The plaintiff's award of damages may be subject to mitigation or reduction if they acted in some way to contribute to the breach. If the plaintiff has already married another individual, it will not affect their ability to recover damages in any way. The fact that the plaintiff married or the plaintiff married another individual does not relieve a defendant of their liability under the promise to marry contract. According to Mensa Bonsu, if the plaintiff succeeds, he or she may be awarded damages in 3 categories: 1. Compensatory damages, aggravated damages, and punitive damages. In Minta vs. Ampenin, where the respondent made a promise to the appellant to marry her and later reneged on it, the Court of Appeal granted the appellant the sum of 6,000 Ghana cedis as general damages to ameliorate her injured feelings. Are there any defenses to a breach of promise to marry? Yes, there may be some available defenses to a breach of promise to marry claim. Most of these have to do with parties' capacity to enter into a valid contract, or the promise to marry was invalid or did not fulfill all of the elements of a contract. After making the promise, the defendant became aware of the plaintiff's condition, which may include incapacity, disease, which would make it improper or unsafe to enter into the marriage. So instead of picking a knife to kill someone, one should pause and remember that there is a remedy in court called an action for a breach of promise to marry, where one can vindicate himself and demand damages for such a breach.